Welcome to Government Contracting Weekly, sponsored by AOC Key Solutions Incorporated. Government Contracting Weekly is the only television program devoted exclusively to the competitive and dynamic world of government contracting. A world where coming in second place is not an option, but where principle-centered winning is the only approach.
Good morning and welcome to Government Contracting Weekly. I'm Jim McCarthy, the owner of Key Solutions and the host of this show. Since the average government contracting opportunity has more than 6 contractors competing, you know that for every winner, there are 5 losers. Over the years, the contractors who have lost a contract competition have looked to debriefings so that hopefully they can learn some valuable lessons about the reasons why they lost. Unfortunately, however, debriefings are considered by some on the government side to be directly related to bid protests, and this perception or reality has had a serious impact on the entire landscape of the debriefing function. Joining me today to discuss the debriefings are 3 members of the NCMA Board of Advisors. First, I'd like to welcome back to Government Contracting Weekly Rob Burton, who is a partner in the law firm of Venable LLP and a former Deputy Administrator of the Office of Federal Procurement Policy. Welcome, sir.
Thank you so much. Great to be here.
Good to have you again. Okay. Next, let's welcome Dick Ginman. He's the Director of Defense Procurement and Acquisition Policy. Good morning, Dick. Good morning, sir. Glad you're here. I shake your hand. Thank you, sir. And then finally, one of our GCW alums, let me just reintroduce Jeff Koses, who is the Senior Procurement Executive at the Office of Acquisition Policy of the U.S. General Services Administration. Good morning, welcome back to you, sir.
And good morning.
Okay. Panel, as always, we have a lot of ground to cover, so let's get right to it. So the first question I'll ask you, Rob.
Okay.
And that is, let's talk about the industry perceptions of debriefings. Now, I'm not saying it's always correct or true, but industry has this perception that the government is so protest adverse that they don't want to give out any meaningful information, or that they are afraid to cross some imaginary line, and that the information that they provide is sort of guarded and it's not really very helpful. Is that the wrong interpretation in your view? Is the U.S. government generally secretive in trying to conduct a debrief?
Well, I think industry's perspective, and certainly a lot of my clients feel that it's not very transparent. The whole process is not as transparent as it should be, that they're not getting really meaningful information. And Jim, the contracting officer has a option whether to give a oral debriefing or a written debriefing, and we're finding some agencies are giving written debriefings that really don't say much at all. And I'll tell you, I think this is systemic of a broader problem, which is really the lack of communication between government and industry. And I do see the debriefings as an example of where communications really break down between government and industry. Now, agencies differ. Some agencies are very communicative and robust in their debriefings, and they give oral debriefings, which are very helpful. Some agencies absolutely are the other way. They are simply not transparent, and they are paranoid about giving any information, because you're right, Jim, they think that the contractor's doing this merely for filing a bid protest. And I think that is a misconception.
You think that overall that's a misconception? What about your thoughts, Dick?
Well, so the real purpose of the debriefing is to help industry understand why they lost, so that they can do a better job the next time.
Yes.
I guess I am sure that from a government perspective there is, with some, a fear of protest. We don't actually get that high percentage of protests, and frankly we don't lose that many. You know, Dan Gordon, who was for a long time at GAO, has recently done a couple of articles on protests, and we do much better than I think most people think. I mean, I have been the range from in a protest with you lost, what else do you want to know? And that's not very helpful. If you really want to avoid the protest, then you need to be open. We actually have a guide that's published for the Department of Defense on how to do protests.
How to do protests, yeah.
I'm sorry, how to do debriefings.
Sure.
Okay. So, you know, our intent is to be as open as possible. There is some information we cannot share. If it's proprietary to the winner, we're not going to share that information with a loser. Right. And then there's some level of we will not share information on other losers. So if industry is coming in that they think they are going to get a debriefing that's not only of the winner and all other losers, then that's an over-expectation on the part of industry.
I see. Okay, Jeff, from your perspective at GSA, how does the agency tend to look at debriefs?
Well, I'd actually like to pick up on Rob's point and hit on that issue of oral versus written debriefings. You know, that's very much a decision that we talk about. It's part of the outplay at the end of the acquisition. So we often ask a couple of basic questions. Who's going to be coming to the debriefing? What are the set of issues that you actually want to talk about? It helps us plan who should be in attendance to get the right folks in the room. But in many cases, yes, we absolutely tend towards written debriefings if we think there's a very high shot of a protest. If we're suspecting that the debriefing is not really about how do I do better, how do I become more competitive for the next acquisition, but if our concern is this debriefing is you're looking for me to make a misstatement, well, in that case, every day of the week, our attorneys are going to push us go towards a written debriefing, comb through the language, get it as safe as possible. That's not good procurement, but that's where we are in.
Let me ask you three gentlemen the same question. What is your reaction if a contractor comes in for a debriefing and has his or her lawyers lined up? Does lawyering up sort of signal something to you?
No.
No?
Oh, no, I disagree.
Yeah.
If I see 2, 3, 4 lawyers coming in, I'm going to have my lawyers in the room. The communication is not going to be as robust.
Yeah. We're generally seeing, we advise our clients not to bring us to the debriefing, and generally we do not attend the debriefing. Because I think it does have a chilling effect on the communication, and the whole idea of the debriefing is to have robust communication. I don't think the attorneys add to that, and as a matter of fact, I would suggest the government may want to think about that as well, because generally the government attorney does attend, and even when we are not there, the government attorney will be present.
So actually, the DoD guidance is if there are not going to be attorneys there, you generally would not have your attorney.
And that's the GSA guidance as well.
Which I think is good.
That's good guidance.
I think that's good guidance.
But again, I just, having attorneys, you can't do a procurement without attorneys. The attorneys helped you put the RFP together, helped you structure it, helped you get through it. I mean, so I don't know. It's not clear to me why I should be in fear if attorneys come. Now, if not from a from a practice perspective, if the attorneys turn it into an adversarial reaction, then the company's not going to get out of the debrief what they wanted to get out.
Yeah, I know there's generalizations, and so I'll be careful not to make them, and I'll say it's probably just my experience. But I tell you, I've attended debriefings with the not very often, by the way, but with the losing bidder. And I leave the debriefing with this sense that, man, I did pretty good. I was great. They were complimenting me here, they're complimenting me there, all this stuff. It was just that the winner just did a little bit better. And that was totally a waste of time for everybody. Is that something that we should be concerned about, this lack of communication that you referenced? Is that part of the problem?
Well, so I guess I would start with, if an offer had virtually, we're required to discuss, or we're supposed to be discussing, significant weaknesses and deficiencies. Yeah. And so if an offer actually had no significant deficiencies and no, significant weaknesses or deficiencies, then we really ought to be discussing weaknesses. I mean, I'm hard pressed to believe in any complex procurement that I have an offer that came in, to include the winner, that didn't have a weakness. I think you really should go back and look at the discussion and what were the questions that were asked of your proposal, because those all were focused on things that either the government didn't understand, they didn't think you were clear on, or they thought you had a weakness, and they should be telling you that in the discussions. That should get you to what should the discussion be in a debrief.
Yeah, I totally agree with Dick on that point. I mean, the focus really should be talking about the weaknesses of the offeror that lost. And that is helpful to the offeror in deciding whether to protest or how to do it better next time. It becomes very helpful.
Okay, well, we're going to step away. I'm sorry, Jeff. We'll come back and we'll continue this discussion on debriefs, and we'll pick up your point, okay? We'll be right back after this.
So, did we win that government contract?
We did.
And?
And now we've got to deal with the regulatory hurdles.
Well, good luck with that.
When the government's your client, you need to play by their rules.
And the rules change more than you think.
Exactly. We need someone who's done this before. Plus, it's complicated, so we're going with BDO.
BDO?
People who know government contracting know BDO.
Working in contract management is a complex job. Creating, executing, managing contracts. It's an ever-changing world, and our members share the same challenges. At the National Contract Management Association, we know this business, gathering the best minds in our field. furthering your career by providing knowledge and training. Together, we've figured it out.
Before we broke, Jeff, you were making or going to make a point, I guess, about the expectations for one of these debriefings. Why don't you continue that? Yeah.
Exactly. I agree with what my colleagues were talking about in terms of the purpose of a debriefing, but often we find that the company coming into the briefing doesn't understand the purpose and thinks that they're there to discuss the winning proposal, to find out what the other company did well, to try and get information about how that offer was put together. As we just laid out, the purpose of a formal debriefing is to go through the relative strengths, weaknesses, deficiencies in an offer. It's also useful, though, to remember that a formal debriefing is applicable when we're talking FAR 15. Often today, we're using schedule contracts where rather than a formal debriefing, what we're talking about is a brief explanation as to the basis of the award decision. So you always want to understand the rules that you're operating under when we move into a debriefing conversation.
I would agree. Let's just change the game here, or the field of play, I guess. What if a contractor agreed to have the debriefing after the protest period has expired, the time for protest? So in other words, the government need not worry at all that there's going to be something that's protestable. Would that change the way the government approaches one of these things, you think? Anybody?
I don't think it should change the way the government approaches it. We're not required to provide a debriefing after the time frame is done. We encourage people to do so. But again, the thing to be careful with in a debrief after a protest is if I offer up new information that was not known before, then I have the opportunity to potentially reopen the protest window. I'd defer to Rob on the specifics of that. But
you agree with that?
Well, I think it's worthwhile, but generally agencies do not do the debriefings. It's discretionary on the part of the
it's not a right that a contractor has, right?
It is in the beginning, but after the time has expired, if you miss the time in which to file your request for a debriefing, then you do not have a right to debriefing. It's totally discretionary.
Totally discretionary. Okay, so
and what contractors need to be careful about, your clock for filing the protest is continuing to run from the date you found out you lost the award, and it does not run then from the time of the briefing.
But if the intent behind it is to help industry do better, then why wouldn't it be a normal course of action to agree to have a debrief after the period so that icy, chilly distance between the two parties would be somewhat diminished? That would be one thing. But the other thing is, what if I, as the contractor, agreed in writing to waive my right to protest in return? Would I get a better debrief?
Again, I just struggle. The quality of the debrief should be the same regardless.
But it's not.
And I think you're kind of idealizing it. I agree that that's the purpose and that's the objective, but we are very much in a risk-averse environment. Dan Gordon's studies show that there's not a huge number of protests, but at the same time, for any major acquisition, we actually have plans in the timelines for a protest at the solicitation and a protest at award. So anything that takes some of the fear out of the process has got to be a boost for communication.
Okay, to any or all of the three of you, would the ground rules be any different when you're briefing a winner versus a loser? In other words, are you more on guard? I know you're not supposed to be, I grant you that, but are you likely to be more on guard if you're looking at a losing contractor across the table as opposed to the winning contractor?
Well, absolutely, and generally winning contractors don't go in for debriefings, although they should, because I think there's something to be learned for any contractor in the procurement process. But generally you have the losers that come in for debriefings. But you make a good point. Winners could also request a debriefing.
I would think so.
They can.
They can, yes.
But they rarely do.
But they would be smart to, I would think.
Yes. So. Absolutely.
Think so.
Absolutely.
Okay, well, what about this? How about a concept of a reverse debriefing? And by that, what I mean is, if the whole purpose is to improve communications and to do better, wouldn't it make sense after the process is over, after all the dust is settled, after the protest period has been done, to let the industry come in and give a debrief to the government on what they thought about the RFP or the procurement process or the selection process or anything like that? Would that be a good thing?
Well, we've got something that at least touches that vein lately. The Office of Federal Procurement Policy has launched a Rate the Agency effort in which we've been putting together a couple of surveys for the unsuccessful bidders on a couple of our recent major contracts, and really trying to get some feedback. Was it a fair process? Was the communication clear? Was there good dialogue? Was there ample opportunity for feedback? Did they understand the basis of decisions? So, it's early. We've only tested the first one, but we're intrigued with the concept.
Intrigued by it.
Well, and DHS, to their credit, has also had seminars or programs where industry and government talk about the whole debriefing process. I thought that was very beneficial, and I've participated in some of those, and I think agencies should do more of that type of post-award communication.
Okay, I understand. Dick, if the contractor, after leaving a debrief, is just genuinely and legitimately dissatisfied or unhappy with the answer, is there any recourse to that contractor? Is there anything else they can do?
I mean, they can submit a written question. We're not required to respond. I guess to what Rob just said, one, if they're really disappointed, then file the protest.
File a protest.
And get the additional information. It's a question of what's a good practice and a bad practice. We're supposed to be open. We're supposed to be clear. But if an offer really doesn't think we did what we said we were going to do in Section M, then they have the absolute right to file a protest. There are companies, by the way, that have as a policy not to protest.
Right.
And if they really feel disadvantaged, they will come in and talk.
In fact, I'd like to take that very point up in our next segment, and that is whether it's really smart inherently to protest against your customer. All right? So we're going to come back in just a second. It's no surprise to any of you that social media has impacted virtually every aspect of our personal lives. Sure, you can say there are both pluses and minuses, but this is the world we live in, and absent a move to a deserted island, there's no getting around it. What is surprising, though, is how some in the government contracting community have not yet fully embraced social media as a business strategy, not only to advance your brand, but also to help win and retain business with your federal customers. At Key Solutions, we believe that social media has to be an integral part of your business development plan. We also believe that while this technology is advancing like a high-speed train, you can either jump on board or watch your competition leave you in the dust. If you are a federal contractor looking to integrate a social media strategy into your business, we will be able to help you. Contact us at aockeysolutions.com. Jeff Koses from GSA, what would you say are 2 or 3 best practices in debriefings that ought to be employed, either on the government side or on the contractor side?
On the contractor side, probably the most important practice, submit the questions in advance. Tell us the key areas that you want to hear about. That way the government can have the right people in the room, can be prepared, can have a better conversation. Okay. On the government side, if I had to outline one, it's rehearse, do a couple of practice sessions, anticipate what we think industry is likely to want to know so we can convey the information accurately, clearly, and not be fumbling around throughout the conversation.
Okay, very good. That's good ideas. Dick, your thoughts?
So I had the right people in the room, particularly if you've given us advanced questions, which I really agree with. Then I can make sure that I have the people that actually run the evaluation team, the people that actually understand the requirement, so that if industry, on the assumption industry has come with the people that actually understand and have put their proposal together, that you have the two groups talking to each other in languages that they are both comfortable in. And the rehearse is really important.
Okay. Rob, you mentioned in one of your earlier responses that you don't generally recommend that the attorneys be present at one of these debriefings. So I'd like to ask you, are there any best practices associated with who should be in the room from the contractor side? From the contractor side now.
Well, I think it's the proposal team, the folks that put the proposal together. But I think our focus should not be on who's in the room as much as what is talked about and what is said. And in this regard, the best practices in my mind are to have first oral debriefings. The idea of these short written debriefings, I think, are really not productive and actually result in a protest more often than not. Case in point, I actually had a client where the debriefing was a short written synopsis that said you were outstanding in all the technical areas, your price was reasonable and realistic. So they said, well, what was wrong? I see no weaknesses, I'm going to protest, only to find out that their price was the highest of any offeror. Had they known that information up front, they probably, I know they would not have filed the protest. So I think that the lack of communication actually creates protest, and I think the government has just simply got to be more communicative. And here's my recommendation for after the debriefing. Instead of just questions up front, I think it's very important, and a best practice that we have witnessed is have questions after the debriefing. Allow the contractor to issue additional questions and have the agency have time to respond to those additional questions.
In due course.
Absolutely, and the agency has the discretion of extending the period of the debriefing. They generally don't, but they could, and they could extend that period of debriefing for more communication, which I think would be really helpful.
If that, in fact, is the purpose of the debriefing to begin with, more communication.
Exactly.
All right, is there, strategically or tactically, should a contractor be concerned about protesting his or her own client, his own customer? In other words, is there a stigma associated with protesting nowadays?
Well,
I mean, it's very common, right? It's very common.
Well, on the other hand, I think only 1% of the government's procurements are protested, so it's really not that frequent.
Yeah.
And I can assure you that a lot of our clients who have fairly good cases do not protest because of what you're talking about. Yeah. They're worried about the government taking it out on them in some way, which I think is really not necessarily a realistic perception on the part of industry.
Yeah.
But it does occasionally happen, so I can understand the concern. But I'll never forget a senior procurement executive who once said to me, you know, we don't like contractors protesting, but on the other hand, if they never do, we don't really take their protests all that seriously. That's an interesting comment, I think. And I've never forgotten that, and I do think contractors need to be very selective about what they protest, but they should not foreclose the possibility of doing that.
Gentlemen, do you think that protest, just for the sake of protest, let's say for an incumbent, is a valid business strategy to say, I'm going to protest and thereby extend my revenue, cash flow for some 90 days or 120 days?
Well,
is that a legitimate business strategy?
Not being in business and on the government side, there's certainly a perception when the incumbent is a loser that protesting is frequently a means to go do that. I mean, at the end of the day, protest is a given right of the contractors, and if they feel they were aggrieved. I think that GAO has a pretty good track record, if the protest is in fact frivolous, that they throw it out reasonably quickly, within the first 6 to 10 days.
Jeff, does GSA have a long memory, if you will, when a protest is lodged? Okay, you got us now, but we're going to get you later.
I'd actually separate it. A company who protests routinely and frivolously on every issue, candidly, we don't really even take the argument as seriously when we see that come in. They're an important check on the system. The occasional protest from a reputable contractor, well argued, well defined, it's a vital check on the system. We don't have a problem with that. But we do have companies who protest everything, and sometimes pre and post toward the same protest over and over again, and that's not of value.
Okay. Well, it sounds like it's a right, but use it with some discretion and some judgment. Okay, well, we're going to step away one final time, and when we come back, I'd like to get your last thoughts on this whole subject. We'll be right back.
FCA has been bringing government and industry together since 1946. By joining FCA, you'll reach the decision makers and become part of the discussion. You'll increase market visibility, gain market insight, receive discounts on FCA member services and events, and manage and engage corporate associates. FCA is the association of choice. Join today at www.fca.org.
Question for you. Do you lack an overall effective win strategy? Hi, I'm Jim McCarthy, owner of Key Solutions. For over 30 years, KSI has helped clients win or retain over $130 billion in government contracts by providing the keys to winning. Now, if you're chasing a must-win contract, visit AOCKeysolutions.com and click on Contact Us. It's a tough market. Don't go it alone. We now come to that regular feature of our program that we say is the takeaways. And so I would ask each of our guests in turn here, if you had one thought, one takeaway that you'd like our audience to come away with from this session, what would it be? Jeff Koses.
Debriefings are part of the whole communication process. We try and emphasize that through the life of the acquisition, from the pre-planning all the way through award and then through administration. Groups like NCMA have a huge role in helping us to promote that communication process, which is why I was really pleased to see them pushing and recommending this topic today.
Yeah, okay, very good. Okay, Dick, your thought.
So we will lose protests because we didn't write down what we did, or
we didn't do what we said
we
to
didn't do what we said we were going to do. Not what we said in the debriefing. So there's no reason not to be open and honest with the contractor in the debriefing with what you did.
Okay, Rob?
I totally agree with Dick, and I think that what's happened over time is that the debriefings have become very antagonistic and adversarial, and I think that both contractors and government officials need to work to change that, to make it more of a dialogue and more of a good communication.
What about this thought, gentlemen? What if there were a designated debriefing official other than the contracting officer, somebody who had no role in this selection, but whose job it was to examine the record and give a meaningful debrief to industry? What do you think?
I think I want the person who is knowledgeable in every aspect in the room and explaining what went on through the program. And I'm afraid a debriefing official wouldn't be knowledgeable enough to make it meaningful.
I think that's a good point. I think the contracting officer really needs to be in the room, needs to be chairing the debriefing session, which is actually what the regulations require.
All right, well, gentlemen, it's been a real pleasure here. So I'd like to thank the National Contract Management Association, or NCMA, for making 3 of their outstanding members of their Board of Advisors available to us today. First off, Jeff Koses, the Senior Procurement Executive at the Office of Acquisition Policy for the U.S. General Services Administration. Thank you, Jeff.
Thank you.
Appreciate it very much, sir. Next, Dick Ginman, the Director of Defense Procurement and Acquisition Policy. Thank you, Dick. Appreciate your being here.
Thank you.
And last but not least, Rob Burton, a partner in the law firm of Venable LLP and a former Deputy Administrator of the Office of Federal Procurement Policy. Thank you again, Rob.
Jim, thanks for having me. Pleasure to be here.
But most importantly, I'd like to thank you, our viewers, for once again making Government Contracting Weekly a regular part of your learning regimen. Now, on behalf of all my colleagues at Key Solutions, I'm Jim McCarthy, and I'll see you next week.
You've been watching Government Contracting Weekly, sponsored each week by AOC Key Solutions Incorporated. Government Contracting Weekly is the only television program devoted exclusively to the competitive and dynamic world of government contracting. For additional information, comments, questions, or suggestions, please write us at governmentcontractingweekly.com.